Ladies and gentlemen, please welcome the Roseville Wrecking Ball. The Roseville Wrecking Ball.
Joshua Shrum. He is a very talented steward, very knowledgeable.
The Roseville Wrecking Ball. This is one of those podcasts where I listen to every episode. I love what he's putting out there.
The Roseville Wrecking Ball. Josh Shrum.
Parcels of Knowledge. Does a fantastic job with that podcast.
The Roseville Wrecking Ball. He is an Article 8 scholar, and thank God. We need Article 8 scholars right now.
Tune into the Parcels of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.
Good morning, and welcome back to Parcels of Knowledge, that podcast dedicated to delivering knowledge to the city letter carrier with your host, the Roseville Wrecking Ball. Today, I am beat. I had two cases that were like 1,000 pages each. That's why I've been working on the last 2 days. And I won my route adjustment grievance, like my special inspection denial. And it turns out they're going to have it this week now. It's all of a sudden, they sprung it on me all of a sudden. It basically, on the 23rd, they said, hey, by the way, your dry run is on the 25th and your round inspection starts the 28th. Holy shit. They barely gave me any time to think about it. So I've been diving into section 2 of the, M39, trying to make sure I'm covering all my bases, making sure everything's correct. So this week is a busy freaking week for me. And I'm sorry, I was going to do an episode on Monday, but holy shit, I've been, it's been very hard. But either way, I know I have to do my favorite thing, Wrecking Crew Wednesday. Today is Wrecking Crew Wednesday, and I'm going to honor those badass individuals that have decided to give back to me and to the community. So, if you don't know what Wrecking Crew Wednesday is by now, it's the Wrecking Crew is a member of my Patreon. If you want to join my Patreon, the link will be in the description below. And without further ado, let's recognize these badass individuals. Last time I forgot Shannon Barger's name. I won't forget it again. All right, Rick Steiner, E.R., Tom Perry, Philip DeGilio, Amy Tyvand, Ryan Ackers, Edmund DeVore, Miziel Guzman, Paul Saranowski, Jamie Gregory, Neil Beckman, Shannon Barger, Kenneth Grigsby, Benjamin Schelhaas, Joni Weber, and our two new members, the Allentown Architect and Self-Care. That's right. We have grown in numbers. It is good to have all these 17 individuals on my side. I appreciate everything you do. And
yes, sir.
Thank you for everything that you put into my podcast. I appreciate all the listeners as well. Again, if anybody would like to become a badass member of the Wrecking Crew, feel free to go and do so. It's going to be a link in the description below. And yes, I'm glad that we're growing in numbers. Yeah, boy. Now, without further ado, let's get into today's episode. Howard Komine, I believe that's how you say his name. He is running for NALC Trustee. And I should have him on my podcast this upcoming Saturday. It might be posted a little bit late because of the time difference. But he's from Branch 860, Honolulu, Hawaii. He's running for NALC Trustee under the CLC slate. So, starting now, send me any question you have for Howard Komine and I will ask them anything. And don't forget, you have a tight deadline. This is going to be expected to be here by this Saturday. Friday would be even better because I might, depending on how it works out, we might do it Friday or Saturday, depending on the recording and when everybody's available. But Howard Komine, he's running for NALC Trustee. Please send me questions. We're going to interview him on Saturday. Now, the Wrecking Crew has been given a poll. This is the second Wednesday that I've done this, where I give them 4 topics to choose from, and whichever topic wins becomes the topic of discussion on Wednesday. They have chosen the topic of defenses to discipline. It won by a 40% vote, so it was kind of a close race. I was actually hoping for Garrity versus Miranda versus Kalkines. That was going to be something I would have loved to talk about, but I'm glad to finally be gauging what people want to hear about. Now, defenses to discipline is an interesting take because discipline, as you may already know, is not necessarily my forte. Don't get me wrong, I'm not bad at it either. I'm just more passionate about contract cases because I'm more of a black and white person in terms of I like to understand exactly whether there is or isn't a violation. And with discipline comes a lot of gray area and a lot of consideration by the arbitrator or whoever is making a decision. So there's a lot to discipline that is intangible in terms of understanding for certain whether you're going to win or whether you're going to lose. What might be common sense to me might not make any sense to the deciding position or deciding person, which would be either step B, an arbitrator, or potentially the local level. But nonetheless, I'm still not going to give any bad information. I'm just simply going to read out of the defenses to discipline. This might be a 2-parter because it's a long book, but it's a good book. So I will make comments on certain issues while I'm doing it that I find might be relevant to talk about. But in general, one thing I want to say before I preface this, when somebody is receiving a discipline, we as a union must request any and all information relied upon in their decision to issue that discipline. That is the first step. You want to hold management to a record what exactly they used to make this discipline. And you want to delve through that information and fight it based on what they said that it was based on. Additionally, you might want to take a good look at the charges. A lot of discipline can be fought with the letter of charges. More specifically, management must prove their burden in any discipline case. Contract cases, it's the union's burden, which plagues me to death. But in discipline cases, it's management's burden. So basically our job as someone that's a representative to fight this discipline is to poke holes in management's arguments because it's their job to present their case. And with that being said, it's their job to prove that this person did what they did and that they deserve discipline for this. That's a little bit hard of a burden to overcome depending on the situation. Obviously, some situations, carriers make it harder on management to prove their burden, and in some situations, carriers make it easier. Just remember, when you're in an investigative interview, that is going to be your time for due process. Management typically would say this in an investigative interview, but a lot of times we don't listen to management because we know what management's up to. They're trying to get us in trouble, so a lot of things go over our head, but that disclaimer about due process is important because it's your time to tell your story. And in such, when they ask you, is there anything else to add? A lot of people say, no, don't add anything. I personally feel the other way around because every PDI is built to display their intent. So like, for example, if you did something that management feels is worthy of discipline, they're going to build an investigative interview to show their case. So essentially, every question is going to be tailored to be, representative of what they want to prove. Like if I was doing an Article 8 case and I knew the carrier didn't tell management ahead of time that they were going to be over, I'm not going to go and investigate that carrier and say, did you tell management? Because I already know the answer. The answer is no. So any answer they know is not going to be preferable to their case. They're not going to ask that question. So when they add, do you have anything else to add? It's their way of making the interview more unbiased. Because now, when they ask that question, it's your turn to insert your case. Because the entire interview was built for their case. Sometimes the answers you say cannot contradict what they're trying to go for because they're particularly biased questions. So I think it's important we as carriers understand our rights, first of all, because if you're going to say something in that last section, you better not implicate yourself, which that's why everyone says don't say anything. Half the people say don't say anything. I disagree. I say get educated, first of all, because if you're going to say anything, of course, it needs to be educated. So you need to understand what your case should look like, and your steward is half of that calculation, because your steward should have given you a pre-interview, meeting where they should have explained, hey, this is what we're going for. They're trying to get you for this. Now you need to tell your case at the end and say it. And in particular, if you feel this way, say it this way. And that's not bad to tell the carrier. Don't tell them what to say, but ask them, hey, did you think you did anything wrong? No. Okay, well then here's how you would say that at the end. So I think it's important that we make sure to make our case at the end of that, because it gives management less of a way out, because any mitigating factors that could have been considered, anything that was incorrect in their line of questioning, should be articulated in that last section when they ask you, is there anything else you'd like to add? Because up until that point, they make their case. Now it's your turn to make your case about your defense. That's what the due process is all about. But without further ado, let's go into this wonderful Defenses to Discipline handbook that the NALC had created. I'm going to skip a couple sections. I'm going to focus mostly on the actual defenses, because a lot of the other stuff, I think a lot of us already know. And if you don't know, I have covered different types of discipline on prior cases. That's pretty much what the first chapter's about. But without further ado, let's start reading the defenses. And I don't know if we're going to get through the whole handbook today because it's going to be a lot. But I'm going to do part 1 at least. All right, Chapter 2, Defenses to Discipline. Just cause. Every NALC shop steward learns that if management wants to discipline or discharge a carrier, it must have just cause. This is required by the second sentence of Article 16.1 of the National Agreement. And 16.1 says, in the administration of this article, a basic principle shall be that discipline should be corrective in nature rather than punitive. No employee may be disciplined or discharged except for just cause, such as, but not limited to, insubordination, pilferage, intoxication, incompetence, failure to perform work as requested, violation of the terms of this agreement, or failure to observe safety rules and regulations. Any such discipline or discharge shall be subject to the grievance arbitration procedure provided for in this agreement, which could result in reinstatement and restitution, including back pay. The just cause requirement is extremely important because it guarantees job security for letter carriers. Unless there is just cause, a carrier has a right to keep his or her job. Furthermore, management bears the burden of proving just cause when it disciplines or discharges a carrier. It is not possible to give a simple one-sentence definition of just cause. It is a term that came from collective bargaining agreements. For decades, almost all labor contracts have required just cause for discipline or discharge. The labor arbitrators hearing discipline grievances under these contracts had to apply this language in deciding whether to uphold or reverse discipline. As they wrote thousands of arbitration awards over many years, they developed an approach for deciding whether an employer had shown that discipline or discharge was fair or justified. Carroll R. Daughtry was probably the first arbitrator to summarize this approach in an arbitration decision. He expressed it as a series of questions or tests. If a disciplinary action passed each of these 7 tests, he called them, it was then for just cause. If the discipline failed even one test, then it was not for just cause. All labor arbitrators should be familiar with the 7 tests, which have been quoted, argued, and written about by uncounted advocates, arbitrators, and scholars. NALC and the Postal Service have agreed to the following working definition of just cause, which is loosely based on Daughtry's 7 tests. It appears under Section 16.1 of the JCAM. Just cause principle. The principle that any discipline must be for just cause establishes a standard that must apply to any discipline or discharge of an employee. Simply put, the just cause provision requires a fair and provable justification for discipline. Just cause is a term of art created by labor arbitrators. It has no precise definition. It contains no rigid rules that apply in the same way in each case of discipline or discharge. However, arbitrators frequently divide the question of just cause into 6 sub-questions and often applied the following criteria to determine whether the action was for just cause. These criteria are the basic considerations that the supervisor must use before initiating disciplinary action. Is there a rule? If so, was the employee aware of the rule? Was the employee forewarned of the disciplinary consequences for failure to follow the rule? It is not enough to say, well, everybody knows the rule, or we posted that rule 10 years ago. You may have to prove that the employee should have known the rule. Certain standards of conduct are normally expected in the industrial environment, and it is assumed by arbitrators that employees should be aware of these standards. For example, an employee charged with intoxication on duty, fighting on duty, pilferage, sabotage, insubordination, etc., may be generally assumed to have understood that these offenses are neither condoned nor acceptable, even though management may not have issued specific regulations to that effect. I'm going to pause here. This is reading straight out of the JCAM, but I do want to say, is there a rule, principle of the just cause test? It is important to understand that a lot of times management will ask, do you know ELM 665.13? But before the employee was able to answer, they will read it to them, which is overriding the is there a rule, is the employee aware of the rule? Because it's talking about were they aware of it at the incident. Once you're reading it to them, of course they're going to be fucking aware of the rule. You're reading it to them. It's not a fair assessment or a thorough investigation of whether or not this employee understood the rule. If I were you and your management team does this, I would re-interview that employee and say, hey, were you aware of it, though, during this time period when you potentially did these things? Obviously, you could implicate them in a degree when you say, when you did these things. So make sure you understand that they, in fact, did do those things. But either way, it's something to be aware of. All right, I'm going to continue. Is the rule a reasonable rule? Management must make sure rules are reasonable, based on the overall objective of safe and efficient work performance. Management's rules should be reasonably related to business efficiency, safe operation of our business, and the performance we might expect of the employee. Is the rule consistently and equitably enforced? A rule must be applied fairly without discrimination. Consistent and equitable enforcement is a crucial factor, and claiming failure in this regard is one of the union's most successful defenses. The Postal Service has been overturned or reversed in some cases because of not consistently and equitably enforcing the rules. Consistently overlooking employee infractions and then disciplining without warning is one issue. If employees are consistently allowed to smoke in areas designated as no smoking areas, it is not appropriate to suddenly start disciplining them for this violation. In such cases, management loses its right to discipline for that infraction, in effect, unless it first puts the employee and the union on notice of its intent to enforce that regulation again. Singling out employees for discipline is another issue. If several employees commit an offense, it is not equitable to discipline only one. Was a thorough investigation completed? Before administering the discipline, management must make an investigation to determine whether the employee committed the offense. Management must ensure that its investigation is thorough and objective. This is the employee's day in court privilege. Employees have the right to know with a reasonable detail what charges are and to be given a reasonable opportunity to defend themselves before the discipline is initiated. Was the severity of the discipline reasonably related to the infraction itself and in line with that usually administered, as well as to the seriousness of the employee's past record? The following is an example of what arbitrators may consider an inequitable discipline. If an installation consistently issues 5-day suspensions for a particular offense, it would be extremely difficult to justify why an employee with a past record similar to that of other disciplined employees were issued a 30-day suspension for the same offense. There is no precise definition of what establishes a good, fair, or bad record. Reasonable judgment must be used. An employee's record of previous offenses may never be used to establish guilt in a case you presently have under consideration, but it may be used to determine the appropriate disciplinary penalty. Was the disciplinary action taken in a timely manner? Disciplinary actions should be taken as promptly as possible after the offense has been committed. Corrective rather than punitive. The requirement that discipline be corrective rather than punitive is an essential element of the just cause principle. In short, it means that for most offenses, management must issue discipline in a progressive fashion, issuing lesser discipline for a first offense and a pattern of increasingly severe discipline for succeeding offenses. The basis of this principle of corrective or progressive discipline is that it is issued for the purpose of correcting or improving an employee's behavior and not as punishment or retribution. All right, that's the end of the JCAM quote. There is even more to just cause under the NALC's national agreement with the Postal Service. Contract language has added some specific requirements for discipline. For instance, Article 16, Section 8 requires higher management officials to review and concur before an employee is suspended or discharged. Article 16, Section 10 prohibits management from using expired discipline as a basis for further disciplinary action. In effect, these extra requirements have become part of just cause under our contract. Different types of defenses to discipline. There are many arguments available to a shop steward who challenges a disciplinary action. This is so because there are so many different elements within the just cause standard, the various elements of just cause, and the arguments that management did not have just cause to issue discipline. It can be divided into three main categories. 1. Management improperly prepared or imposed the discipline or improperly processed the grievance. Much of the just cause requirement focuses on how management goes about preparing to impose discipline and actually imposing the discipline. For instance, it must investigate the facts thoroughly before it decides whether to go ahead with discipline. This kind of argument is known as procedural or due process challenge to a discipline. 2. Management failed to meet its burden of proof. Management bears the burden of proving that the grievance acted as charged. Proof of misconduct is called the merits of a disciplinary grievance because it is the heart of the matter. If the union can show that management's proof is weak or otherwise faulty, then there may not be just cause for the discipline. 3. Management imposed discipline that is too harsh. NALC often argues that the level of discipline imposed was too severe. For instance, NALC may cite mitigating circumstances. To mitigate means to make less harsh or severe. Or the union may argue that the discipline was punitive rather than corrective and progressive. Although the carrier may have acted as charged, we argue that management should have issued lesser discipline or none at all. State multiple defenses separately and alternatively. The NALC will often try more than one of the above categories in a single case and sometimes use all of them. When multiple defenses are used, they should be stated separately and argued in order in which they are presented above. Thus, a summary of the argument of a grievance of a letter carrier with 32 years of service charged 2 months after the fact with discarding deliverable mail might be as follows. The discipline should be disallowed as untimely. Even if the discipline was not untimely, the discipline should be disallowed because management failed to prove that the grievance acted as charged. Even assuming that the grievance acted as charged, the discipline imposed is too harsh given the grievance 32 years of discipline-free employment. A series of arguments stated separately and alternatively, even assuming, as above, gives the arbitrator the maximum number of hooks upon which to hang his or her hat, even if 2 of the arguments are to be found totally unmeritorious, prevailing on whichever remains at least a partial win. All right, so Section 1, merits. Here we go. Yeah, we're only going to do a couple more sections, and I think I'm going to do another episode either on Thursday or Friday. It's most likely going to be tomorrow, Thursday, and we'll wrap up this defenses to discipline. So, Section 1, merits. Disputes around the correctness or completeness of the facts used to justify the discipline. The experienced NALC stewards and officers are familiar with the elements of just cause, the contract's due process requirements, and many defenses to discipline that can be used to defend letter carriers. Yet sometimes we can all lose sight on one truism that all experienced union advocates eventually learn. Most discipline cases are decided by the facts. Section 2 of this chapter discusses in great detail the various technical and due process arguments available in disciplinary cases. To be sure, when these arguments are available, they should be made. However, in the great majority of successful discipline cases, arbitrators make their decision based on the merits of the case. The defense that management failed to prove the grievance acted as charged is available in every discipline case. This is so because whenever management issues discipline, it assumes the burden of proving that the grievance acted in such a way as to provide just cause for discipline. To meet this burden, management must come forward with probative evidence sufficient to convince the arbitrator that the misconduct with which the grievance has been charged actually occurred. Management's proof must be in the form of evidence. Arguments, assumptions, guesses, conjectures, allegations, or speculations are not evidence. Testimony of a witness who has personal and direct knowledge is evidence, as may be photographs, fingerprints, and documents. The union does not bear a corresponding burden. It does not have to prove that the grievance did not act as charged. Instead, the union's job is to poke holes in the proofs offered by management. That is not to say that the union should waive its opportunity to present its side of the case. If the union can prove through its own presentation of evidence that the grievance did not act as charged, so much the better. The arbitrator's primary function in a typical discipline case is to weigh the evidence to determine whether the evidence is sufficient to conclude that management has met its burden of proof. In performing this function, the arbitrator must decide the weight, if any, to be given hearsay or circumstantial evidence. And if witnesses have given testimony which is contradictory, the arbitrator must decide whose testimony is to be credited and whose discounted. Arbitrators must decide the amount or level of proof or the quantum of proof needed to support the charge. When preparing a defense to discipline on the merits, you should look at other discipline cases having the same charge. By doing so, you'll be able to identify the kinds of arguments and evidentiary problems that may be specific to certain charges. For example, the patterns found in falsification of employment application cases are quite similar to each other, but are quite different from the fact patterns found in cases in which discarding deliverable mail is charged, and the methods used by arbitrators to resolve disputes of fact in the two kinds of cases is also quite different. Chapter 6 of this publication provides guidance on handling many of the more common disciplinary charges such as attendance, accidents, and unauthorized overtime. Definition of burden of proof. The phrase burden of proof is actually a combination of two different concepts that develop in the case. Stewards should keep them in mind as they investigate and prepare cases. First element is the burden of persuasion. The burden never shifts when the case is reviewed and is borne by the party initiating the action. In contract cases, the union has an ongoing burden of persuading the arbitrator that a contract violation has occurred. The reason this burden falls upon the union is that the national agreement gives management the right to make many decisions affecting the wages, hours, and conditions of employment of letter carriers. However, these rights are not absolute. Article 3 specifically states that those rights are subject to the provisions of this agreement and must be consistent with applicable laws and regulations. The Article 15 grievance procedure describes the procedure by which the union may seek relief if they believe management has not lived up to the provisions of the national agreement. Thus, as the party claiming a violation of the contract, the union has affirmative burden of persuasion to establish the contract violation as fact. Discipline cases are different, because Article 16 states that no employee may be disciplined or discharged except for just cause. Management has contractually assumed the burden of proof there was just cause for any disciplinary or discharge action it takes against the letter carrier. The second element of burden of proof is sometimes known as the burden of going forward with evidence. This burden shifts through the hearing as each party meets the burden of proof relative to an argument or contention. Arbitrator Hugh W. Babb explained in these concepts in this way. While the burden of proof remains on the party affirming a fact in support of its case and does not change in any aspects of the cause, the weight of the evidence shifts from side to side as the hearing proceeds, according to the nature and strength of the proofs offered in support and denial of the main fact to be established. Prima facie case. A literal translation of the term prima facie would be first face, or as we say in modern English, on the face of it. It means that standing alone, unrebutted, the evidence presented by the moving party would warrant a conclusion which supports the party's allegations. In an arbitration hearing, the party bearing the burden of persuasion has the initial obligation to establishing a prima facie case. If it fails to do so, the arbitrator may make a ruling that effectively ends the proceeding. However, if the moving party establishes prima facie case, the burden going forward with evidence shifts to the opposing party. In a non-disciplinary case, the union must present sufficient evidence to establish there was a contractual provision limiting management's rights and that such a limitation was exceeded or not followed. If the union is able to do so, management must then produce evidence refuting the union's case or excusing its own actions. In a disciplinary case, management has the initial obligation to go forward and establish that there was enough evidence for the record to support that the conclusion that there was just cause for the discipline. If they do so, the burden shifts to the union to prove management's contentions false or to provide justification for the employee's actions. The conclusion to be drawn is that while one party will retain the obligation to persuade the arbitrator of their position as an underlying principle in any arbitration, once they have established a prima facie case, the burden shifts to the opposing side to rebut that case. If they fail to do so, the arbitrator will find for the moving party. Types of proof. All right, so according to Black Law Dictionary, the definition of proof is the effect of evidence, the establishment of a fact by evidence, any fact or circumstance which leads the mind to the affirmative or negative of any proposition, the conviction or persuasion of the mind of a judge or jury by the exhibition of evidence of the reality of a fact alleged. Proof is the establishment by evidence of a requisite degree of belief concerning a fact in the mind of the trier of fact or the court. Thus, it is clear that proof is established by the production of evidence. Evidence is established in three ways: the oral testimony of witnesses or the production of documentary or physical evidence. Oral testimony is evidence which is given by word of mouth. The ordinary kind of evidence given by witnesses in court or arbitration hearings. There are several types of oral testimony. Eyewitness testimony is the oral expression by a witness about an event or act to which the witness was present in some manner. The witness recounts what he personally saw, heard, felt, or perceived. For example, an employee who witnessed an accident may be called to testify about what he saw. Expert testimony is the opinion of a person who possesses special skills or knowledge in some particular science, profession, or business, which is not common to the average person and which is possessed by the expert by reason of special study or expertise. For example, although the expert witness did not see an accident occur, she may be called to express an opinion as to matters involved in the accident based on her investigation and expertise. Documentary evidence is that which comes on some form of paper or other material substance and would included documents, forms, records, files, written statements, notes, photographs, charts, graphs, written policies, and memoranda. Physical evidence includes any inanimate objects admissible for the purpose of proving a fact, such as a scanner, pieces of mail, a postal vehicle, or a visit to the location of an event. Types of evidence. Direct evidence is proof offered in the form of testimony from a witness who actually saw, heard, or experienced the subject of interrogation. It is evidence which, if believed, proves existence of a fact without inference or presumption. That is, it establishes the existence of a fact without the intervention or assistance of the proof of any other fact. This is the strongest form of evidence, and unless specifically rebutted or not believed, will generally be accepted as fact. Circumstantial evidence is a testimony that is not based on actual personal knowledge or observation of the facts in question, but of other facts from which deductions are drawn. For example, a supervisor testifies that she saw a carrier place something in his coat pocket, but did not actually see what it was. When the carrier's pockets are emptied, a piece of registered mail is found. While the supervisor did not actually see the carrier put the mail in his coat pocket, it is inferred that the carrier put the registered mail in his pocket. Circumstantial evidence can be very persuasive, unless a plausible alternative explanation can be made. Hearsay evidence is a testimony of a statement made by someone else offering as proof of a matter being stated. The general rule is that a witness may tell only what he or she personally observed through one of his or her own senses. A witness cannot tell what was learned from somebody else secondhand. For example, testimony from Supervisor Jones that Frank Smith told her that he saw Carrier Bob put the letter in his pocket would be direct testimony about what Smith told Jones and might be sufficient to prove that Smith uttered those words, but it could not be given much weight as proof that Carrier Bob put the letter in his pocket. In most cases, an arbitrator will probably not allow this kind of testimony if it was objected by the opposing advocate. Some forms of documentation can be considered hearsay. For example, NCIC computer printout showing that a carrier had been convicted of a crime would be hearsay, as it is a record of a record, not the actual document itself. An authenticated copy of the actual court record showing the conviction would be direct evidence. So let's take a look here. We're going to go to Section 2, and that'll be our last section for today. Section 2, Management Action and Responsibilities. Allegations that management improperly prepared or imposed a discipline, or that management improperly processed a grievance. Many of the elements of the just cause standard focus on how management goes about preparing to impose discipline and actually imposing the discipline. For instance, it must investigate the facts thoroughly before it decides whether to go ahead with discipline. This kind of argument is known as a procedural or due process challenge to discipline. In addition, Article 15 requires management to do certain things while processing a grievance challenging discipline. For instance, management must give steward paid time to process grievances, must provide relevant information to the union, and must allow employees to exercise their Weingarten rights. These requirements do not always fit into the formal definition of just cause. Still, they are basic elements of fairness, and arbitrators have refused to uphold discipline when management has ignored them. You know what? We're going to stop right here. I know this is starting to get to the best part, but I'm going to save the best parts for tomorrow because I feel like this podcast is long enough today, and I got to get going preparing for this dry run and this route adjustment. I'm going to spend more time tomorrow talking about defenses to discipline. And don't forget that we have Howard Komine coming on Saturday. He is running for NALC Trustee. Please send me questions so I can ask him anything that you think he should have to answer to. You can send those questions to Rosevillewreckingball@yahoo.com. That is rosevillewreckingball@yahoo.com. If you don't want to guess at how you spell that, I will put that in the description below. So hopefully you learned something valuable today. And as always, have a good day.
If these guys are getting educated, we will be in big trouble.
Management's been weighing you down like a bag of wet catalogs, but you don't gotta take it. You strap on the elbow of education, dig it?
Ladies and gentlemen, please welcome the Rosevillewreckingball. The Rosevillewreckingball.
The Rosevillewreckingball is an Article 8 scholar, and thank God, we need Article 8 scholars right now. The grievous genius, the Rosevillewreckingball, doing amazing work.
Tune into the Parcels of Knowledge podcast while you're on the route. That's the mailman's playbook, brother.